Simulation number 5, mediation, final report. The settlement is made on this day on 8th March 2023 between Arvind Hyderabad of one part and Hyderabad Ventures on the second part and Silo Systems of the third part. Whereas certain disputes regarding IPR of software developed by the party on the one part, licensed shared with the party of the second part and allegedly stolen through an employee of the second part by the party of the third part, and the party of the third part applied for a patent based on the same. And whereas the parties agreed to submit their dispute to mediation under ICADR rules of mediation, the parties have undergone the 6-step process as below. 1. Mediator opening statement. 2nd. Disputing parties opening statement. 3rd. Joint discussion. 4th. Private caucuses. 5th. Joint negotiation. 6th. Closure. Now the parties hereby agree to a settlement of the different aspects of disputes as follows. 1. This is a court-annexed mediation process. 2. Mediator appointed by the court, that is the student name. 3. The dispute is referred to in mediation as per ICADR rules and protocols and procedures. 4. The place of mediation is Hyderabad City Civil Court. 5th, mediator's opening statement regarding facts of the case. Mr. Arvind is a software developer based in Hyderabad. He developed a software useful for private colleges. He entered into a venture capital finance agreement with Messrs. Hyderabad Venture Capitalists along with a non-disclosure agreement and an agreement that allocates software development duty to Mr. Arvind and patenting, copywriting and marketing and licensing responsibility to Mrs. Hyderabad Venture Capitalists. Silo Systems acquired the program code created by Mr. Arvind and shared in confidence with Hyderabad Venture Capitalists through the medium of an employee of Mrs. Hyderabad Venture Capitalists by means other than those disclosed publicly. Ms. Silo Systems has applied for a patent copyright on the said program with the authorities who published the application on their website, from where the party of the first and the second part came to know of their loss and raised a dispute. Opening statement of Mr. Arvind. I have developed a software for college management system useful for private engineering colleges and entered into agreement with Mrs. Hyderabad Venture Capitalists for onward licensing, marketing and patenting of the same. Silo Systems has, however, applied for a patent of a pirated version of my software and hence this dispute. Opening statement of Representative Hyderabad Venture Capitalists. We have invested in the software being developed by Mr. Arvind and agreed to put it up for patent. Sale and license. We obtained a copy from him and were in the process of packaging it and marketing it before applying for a patent for the product when we learnt that Mr. Silo Systems has already submitted an application for patent of CMS system which bore an uncanny resemblance to our own product. On making inquiries, we found that one of our employees working in a patent section with us had passed on the entire code to Mr. Silo Systems based on which they applied for a patent on a pirated version, hence this case. Opening statement of Ms. Silo Systems. We have been developing a CMS for quite some time and we employed one of our experts as well as some outside experts for the purpose. After completing it, we have developed various versions of our software and the present version 3.5 has no code that can be claimed to be the same or similar to that of the Party 1 code. Our GUI, of course, bears some similarity as both of us are catering to the same colleges with the same or similar needs. Joint discussion. On a sitting meeting of all the three parties, it was found that their CMS version 3.4 bore at least 35% of the common code as with their Party 1 code, while version 3.5 CMS did not have any code that was similar to that of the main code. On further discussion, it was discovered that the version 3.5 of the silos had non-literal components and GUI components which were very similar to the main program. Analysis by the mediator presented to Silo Systems. A discussion of the computer program was initiated by the mediator to clarify the situation and clearly indicate the abstraction, filtration, comparison, three-part test to analyze the non-literal infringement claims in computer software. Cross-reference Computer Associates International Plaintiff versus Altai Inc. Defendants USA June 22, 1992. Copyright law seeks to establish a delicate equilibrium. It affords protection to authors as an incentive to create. On the other, it must appropriately limit the extent of that protection so as to avoid the effect of monopolistic stagnation. Balanced view to be taken of the literal aspects of the code and non-literal aspects of the code that are subject of piracy. Computer program design. Computer programs is a set of statements or instructions to be used directly or indirectly in a computer in order to bring about a certain result. The programmer works from general to specific. The first step is coding is to identify a program's ultimate function or purpose. Example, creation and maintenance of a fees ledger. Once this goal is achieved, the programmer breaks down the decomposes the program ultimate function into simple constituent problems or subtasks called the subroutines or modules. Example, updating a list of outstanding accounts receivables. A subroutine may be broken down further into subroutines. Programmer will then arrange the subroutines or modules into what are known as organizational or flowcharts. Flowcharts map the interaction between the modules that achieve the program's end goal. To accomplish this, he must design each module parameter list. Parameter list is the information sent to and received from a subroutine. It refers to the form in which the info is passed between the modules and the info is actual content. With respect to form, interacting modules must share similar parameters lists so that they are capable of exchanging information. The function of modules is a program together with each module. Relationships to other modules constitute the structure of the program. Structure may include the category of modules called macros. A macro is a single instruction that initiates a sequence of operations or module in the actions within the program. Very often, the user will accompany a macro with an instruction from the parameter list. We refer to the instruction. In fashioning the structure, a programmer will maximize the program speed, efficiency, user simplicity of operation, memory constraints used to run it. This stage of program design is time and investment intensive. Once modules are identified, designed, and relations laid out, program structure is finalized, embodied in a written language called coding. The structural blueprint, source code, using BASIC for example. Second step is translator or compiler into an object code, that is machine readable form. After coding is furnished, it will run the program to find the logical and syntax errors, debugging. It's called debugging. Once done, the program is complete. In order to establish the piracy, one step compare word for word literal content. Second step, compare based on abstraction, filtration, and comparison. 3 steps test comparison done at routine, subroutine, module, flowchart, parameter list, macros, structures, program design level, and decide on the similarity and piracy. It was discovered by the above analysis that 3.4 version had 35% literal similarity or sameness, and the version 3.5 had 0% common words, thus escaping the copyright violation charge. But the flowchart, program design, and macros level of non-literal items comparison was more than 80% same or similar, thus proving the charge of piracy and subsequent modification of code language and the coding per se. Individual discussion of moderator with cello systems. Moderator detailed the manner in which the abstraction, filtration, comparison works to prove piracy and obtain their concurrence to the fact that their version 1.0 to 3.4 was copied from the program of party number 1 and later on it was modified to consciously modify or change the literary aspect and words of the code so that it is not caught under charge of piracy. Joint discussion. The party of the third part had now come round to the view that he should own up to the piracy background and offered to withdraw the patent application and allow the party of the second part to file a fresh patent application with a condition that he would get a license to the program to be used for his commercial activity. There was thus a commonality of ground achieved in all the three parties, and the mediation was successful and settlement arrived at and signed by all the three parties, and mediation in and witness to the settlement. The final report, which was submitted, which was a success settlement, a report was submitted to the court for it to provide a decree on the consent decree signed by all the parties.